that she was white. So after the 14th Amendment, this then could be applied to African American men. So marrying a woman who was not a citizen could enable her to be a citizen. After the Dawes Act in 1887, certain Native American men who were willing to abandon their tribal land and tribal jurisdiction they'd previously been under, they also could become citizens, and this right was expanded to some Native American men. So after the late 1880s, there was a small group of men who could, or no, actually a large group of men, white men, African American men, and some Native American men, who, if they married a woman who was one of those racial categories, could confer citizenship on her by marriage. Excluded from this, as some of the other speakers have already mentioned, were people of Asian descent. The Chinese Exclusion Act in 1882 made permanent aliens of non-citizen immigrants. So birthright citizenship was the only access to citizenship for people of Asian descent or from Asian countries. So this was an interesting way, an interesting access point for citizenship among women who were married to citizen men. But what about a female citizen, a woman who was a US citizen, who married a man who was not a US citizen? Did the same thing hold? If the idea is that everyone has equal citizenship, then that should work in a reciprocal fashion. But because of the ways that women's citizenship was often derivative, because of these ideas of coverture, that wasn't always the case. So initially there wasn't a clear law about this. The 1855 law didn't specify what happened in the reverse case. But immigration was a major concern in the late 19th century and early 20th century, just as it is today in some ways. So with a new immigration law in 1907, a woman could lose her birthright citizenship by marrying a man who was not a citizen. At that time, the law followed what a lot of European countries were doing, and it showed that Congress viewed women's citizenship as derivative of men's, and generally viewed women principally as dependents rather than as these active kinds of citizens. So this was the era, 1907, this was the era of the women's suffrage movement, and already women could vote in a few states. And in California, women got the right to vote in 1911. So in 1911, a woman in California named Ethel Mackenzie went to register to vote. And she was told she could not register to vote because she had married an Englishman. They lived in California, but by virtue of marrying a man who was not a citizen, she lost her birthright citizenship. And the Supreme Court upheld this decision, saying that by consenting to marry her husband, Ethel Mackenzie had consented to abandon her US citizenship in order to unite with her husband. And so the idea was that consent is involved both in marriage and in citizenship, but that it could be in an exclusive way, particularly for a woman who married a man who was not a citizen. So in the 19th Amendment, ratified in 1920, it guaranteed women's right to vote. Or more precisely, it prohibited the denial of the right to vote based on sex. So the importance of that negative statement is that it actually did not necessarily protect African American women's right to vote, because it meant that the right to vote could not be denied along lines of sex, but for African American women who already faced discriminatory laws in a variety of states, it didn't restore those rights. But following the 19th Amendment, advocacy from women's rights groups worked for a broader understanding of women's citizenship. So in 1922, 2 years after that amendment, the Married Women's Independent Nationality Act, or the Cable Act as it was called, gave women some degree of independent citizenship. So a woman like Ethel Mackenzie, who'd married a man who was an Englishman, was still able to vote. She was able to hold on to her 19th Amendment rights. But that wasn't necessarily the case for every woman. So the Cable Act only affected women like Ethel Mackenzie, who had married a non-citizen who was, quote, eligible for citizenship. So her husband, being from England, could ostensibly be naturalized as a US citizen. But that eligibility for citizenship was defined in racial terms, so that it didn't apply to women who married men who were, for instance, Asian citizens or Asian Americans who were not citizens. So I'm going to tell you about the final woman I want to mention to you is a woman named Fung Sing. She was born in 1898 in the United States of immigrant parents. So she had that birthright citizenship when she was born in 1898. In 1903, as a girl, she moved she moved to China, where she had family. And in 1920, she married a Chinese man. Now, he died 4 years later, so she was a widow as of 1924. And in 1925, looking to start a new life, she returned to the United States, the land of her birth, of her citizenship. But she was denied entry. She was told was not a citizen because she had married, even at the late date after the women's right to vote had been secured by the Constitution, she had married a man who was ineligible for citizenship. And so that continued to be the case even after the passage of the Cable Act. Now, in the 1930s, the Cable Act was amended to extend more broadly to women, regardless of what non-citizen alien they might have married, whether he was eligible for citizenship or ineligible. But what I hope I've shown in these few examples is that women's citizenship has often been a very odd case. Not only has citizenship not necessarily conferred the right to vote, but women's citizenship, particularly that of married women, has often been less secure than that of men or single women or married men in this country. So while married men could, by virtue of marrying a non-citizen, make her a citizen, women would lose their citizenship in certain years of our nation's history by marrying a man who was not a U.S. citizen. So I want to sort of bring these examples out as a way of troubling our idea that birthright citizenship has been a clear thing. Obviously, it's part of our Constitution after the 14th Amendment, but it has had its ups and downs and its challenges. So I look forward to more conversation and maybe questions from you all about these things. But I wanted to bring up these instances of particularly women's citizenship as a limited and questionable category. Thanks.
Now it's our hope that our panelists might make trouble for each other, 2 or 3, and then we'll open the floor up for questions. So, Professor Lazarus, since you're a known troublemaker, we probably should start.
Well, I guess I've been here long enough to have a reputation. That's a good thing. No, I think I have to say we spent about an hour trying to figure out what we were going to say, but I think we sort of progressed along in a fairly logical way, as if we planned it. I think we sort of did. I think the issue I'd like to point out is that citizenship, from the beginning, as I think all of us have said, this issue, these legal issues of citizenship arise when there's a problem that has to be solved. And that concept, as I've pointed out, of citizenship itself arises that way, but it's interesting the role of African Americans in 1857. It's the Dred Scott case which sort of brings this issue to the table. But after the Civil War, there's a problem that has to be solved. I mean, we're gonna free the slaves. We're going to give them the right to vote. We have to figure out the citizenship problem. And I think the case of women is really interesting because it's citizenship is an issue only if you stand up, as these women did, and said, okay, I want to do something or not do something, and I have the right to do or not do that thing because I'm a citizen. And until you do it, the problem doesn't show up. So particularly in the political realm, you talk a lot about voting, but I think it's also true as women become more involved in the economic realm. In fact, as all of these groups become more involved in the economic realm from the very beginning. I mentioned the peasants in medieval times. No one cares. They're not doing anything. They're not going to. So all these issues are almost moot points. Whether you're a citizen or not, if you can't vote, if you're not working, if you're not playing that active role of citizen, these questions in a sense don't come up, or rarely come up. And when they do, we kind of scramble to find solutions to those problems. So I like the way that kind of tied into what I was saying.
Looking to you.
I haven't been here long enough to make trouble.
You've been here longer than I have.
Yeah, that's true. That's true. The one thing I left out, but I think would go to both of my colleagues' really superb presentation, which I learned a lot, and thank you both. The state and what we think of as federalism and how it played out, both for women's rights, where women in Wyoming could vote. Maybe it was Montana, I get them confused. African Americans, there were 5 states that could vote in before the Civil War. At one time, free African American vote in North Carolina before, then it was revoked. But how the states play in. And what Bill just said about African American, I think is particularly important, not just on the 14th Amendment, which we're so concerned now about natural birth citizenship, but the 15th Amendment, how that's played out, where if you study demographics, I guess we're all sort of people who look, well, maybe a political scientist looks to the future. Most of us are looking to the past. That Texas is now a minority state, if you add that as African Americans, Asians, and the Hispanic population there. So this concern about the right to vote. So I think the state makes it really complicated. We've been talking about the individuals, so then you have the state, and that was where the rights to vote was determined, and really, in some ways, citizenship itself, until you had the 14th Amendment. And that's what I was trying to say in that roundabout way about how the 13th, 14th, and 15th Amendment gave Congress, or at least the federal government, the power to say that these rights are guaranteed, even if the state says you cannot vote. And of course, discrimination all those years was found, a long time there was a distinction that individuals had the right to discriminate. The state couldn't, but then eventually got to even the state was ruled that it could discriminate, and now of course that's reversed. So I don't know if that makes sense or not, but I'm just trying to say it's even more complicated than we made it out to be by leaving things out. And it's not an easy, I think, it's not a dichotomy at all. It's very ambiguous. And that was the point, without having time to make it, that I wanted to bring in Justice Harlan, who had been seen for years as this champion, but of African American right. Here was a Kentucky slave owner who had been the champion of African Americans, except he was certainly no Earl Warren, a later Supreme Court, in fact, Chief Justice, but in general, except for a few cases. But he was always anti-Chinese in his dissent on Plessy v. Ferguson, which many have held as one of the great dissents of all time. Then he said, well, but this doesn't go for Chinese. So he was anti-Chinese, not anti-black, and that would fit in with his own dissent in the case that really establishes for what we think of as illegal, not documented workers, the 1898 case on Chinese, that he has his own prejudice playing out there.
So if I could add just a couple of things, I want to touch on sort of this question of economic involvement and citizenship, and this question of what the 15th Amendment might have to say about this. So, and how these prohibitions against discrimination are things that get circumvented in various ways, as we've seen in a lot of this history, and maybe what that could mean.
And still are.
Right, and then I have to say, and maybe what that could mean for today. So one thing, interesting things about this economic question was that when there were a variety of restrictions on emigration, women in particular were seen as a vulnerable category, particularly in cases of the Chinese Exclusion Act and prohibition of immigration from China. Women were seen as vulnerable to being forced into prostitution because of their lack of other types of economic activity. So if a woman was not the wife of a well-off man, it was very hard for her to emigrate in any way. And so what was seen, this legal prohibition, it was meant to sort of stop the importation, forced importation, the human trafficking of Chinese women as prostitutes, really served as a broad way to prohibit women's immigration from China based on economic reasons. So if a woman couldn't prove that she was attached to a very well-off man as a wife, she was seen as a dangerous type of a dependent. So that's interesting how women's involvement, that happens in other places too, where a single woman can emigrate, but perhaps a woman with young children could not. Because if she could be seen as a worker, if she could be a maid, if she could be some type of domestic worker, she was more likely to be able to emigrate than if she was seen as a dependent who might end up relying on state funds or state support. So I think that's an oddity of how this economic participation works with abilities to immigrate and citizenship. The other thing I want to mention about this question of discrimination and citizenship. I mean, one thing that the 15th Amendment, so we didn't talk about that, the next major Reconstruction Amendment, prohibits denying the right to vote on the basis of race, color, or previous condition of servitude. So like the 19th Amendment about women's right to vote, it doesn't say all people of African descent or all African Americans or all former slaves can vote. It says states can't prohibit the right to vote on those grounds. So what's interesting to see, and something I'm looking at in the book I'm writing, the ways that when southern states want to get around that, how they do it. In the case of Mississippi, which had the first state constitution designed specifically to disenfranchise the African American voter majority, people really worried about it. I mean, they brought preachers in to pray for their ability to come up with a constitution that would prohibit African American men's right to vote. And that's where they came up with ideas of grandfather clauses, of literacy tests, and of poll taxes that would become hallmarks of Jim Crow segregation and of African Americans' restriction of the right to vote throughout the South. And so I want to suggest that perhaps those things aren't all the way gone today. If we think about what people have called the new Jim Crow and the disenfranchisement of people with felonies, I think that that could be another instance. If you look at the demographics of who that affects, you look at the way our criminal justice system is set up, the people whose right to vote has been taken away because they have a felony record are overwhelmingly African American and Latino men. And so if you map on the numbers of people whose right to vote has been removed, it's been restricted by that. Again, it's not in prohibition of the 14th or 15th Amendment. It's not in direct prohibition of other restrictions on the government's ability to discriminate. The disenfranchisement of felons is another way where citizenship can not be lost entirely, but certain rights associated with it can be taken away.
As is photo, in-person
So,
photo ID.
IDs.
We'll get into that. And I wanted to, I don't want people from South Carolina to feel bad. Mississippi did get theirs first, but South Carolina was second.
It was.
And,
Just
and they were the only two because states were afraid what the Supreme Court would rule until the Mississippi, South Carolina, but really Mississippi case was ruled on. The other thing that I think is worth considering is this. There's been a lot of concern about immigration from different groups of people. People were worried about the Irish. You've heard the old saying, no Irish should apply. Then when different sorts of people were coming, particularly those who were darker from different part of Eastern Europe, there were concerns about Italians and others. And so there's been a lot of, for lack of a better term, a native reaction. But only now have we really dealt with this idea of citizenship, birth issue. So I find that interesting because you can go back and there's some horrible language by some very prominent people anti the people, and there have been restrictions on migration, who can come in and from what area at what time. A lot of this tied to what you both were talking about the economics, I think, and who people needed, as we still do today, in terms of for a thriving economy. But the idea of birth citizenship has never really been raised until recently.
Yeah, if I can say one more point. I mean, Vernon's point about the federalism issue, I think, is really critical. In Europe right now, I mean, there's this very serious question: what does European citizenship mean? And the fact on the 14th Amendment, you are, as Vernon said, not only a citizen of the United States, but of the state in which you reside. And that's how us Yankees can come down here and live here and be citizens of South Carolina, because once you're a citizen of the United States, you can go anywhere. And that's something we shouldn't take for granted. It's something we do take for granted. You know, the job boards, if you're in political science or history or any field you're in, you go on monster.com or whatever, you can work anywhere in the country without any legal restrictions. I spoke this morning on same-sex marriage case, and in answer to a question, I said don't underestimate the fact that I think 300 organizations, companies, the military, et cetera, were specifically in favor of the court's same-sex marriage decision, because Boeing doesn't want to have to deal with the problem of can we send a married same-sex couple to work down in South Carolina, a person saying, I'm not going there because my spouse isn't my spouse anymore. Right? So the economic and the discrimination and the federalism, they're all kind of intertwined in make this all, I don't know if it's complicated things like you said or clarified.
It's more what really is. I mean, it's we like to do the 1, 2, 3. These are the reasons, but it's usually a lot more ambiguous and more complex. And what you just said is absolutely right. That Bowen and others have said that. I mean, ran into problems. I like to say two things changed the American South: air conditioning and the Voting Rights Act. And we actually know more how better how air conditioning works. We do the Voting Rights Act because we understand science is important, but we aren't so sure, I think, about democracy and government and the Constitution. Yet I think they're central in all of these.
Please, the questions you may have for the panel? The professors of political science can ask questions. Not point to anybody in particular. Yes, please.
Just for anyone who wants to answer, but today, what effects or negative effects has the terrorism label? How is that affecting citizenship today negatively? Such as they wanted to try the Boston bombers. Some people wanted to try them as foreign combatants, and some American citizens have been killed overseas by wrongly such. And people have questioned whether they have the right to do that as American citizens. So, anyone wants to answer it? Talk about that?
Well, so the United States has criminal jurisdiction over persons who are not citizens. So on that side, if it's a question of someone coming from abroad, their status, the fact that they're not citizens doesn't really matter. I mean, they can be tried in court the same way. The issue that you raise is an old one, and it's what happens when an American citizen fights for a foreign enemy, and how do you deal with that person? And you can always use treason, but treason is really problematic because it requires confession in open court or the testimony of two witnesses, and it's just a long, drawn-out procedure. And so often what the precedent, that the easier way to deal with U.S. citizens who went over to the enemy was to simply was to subject them to military, either to military justice, which you can do either because they're a foreign combatant or because they were in the military and acted illegally. So citizenship has not been a protection, I guess I would say. It hasn't protected people. The lack of citizenship doesn't really matter, and then being a citizen, if you do things against the United States, has not protected you legally either. At least, I don't know if that's your question.
Yeah, well, yeah, that touches on it. But do you think that can unfairly affect some people, and that they may lose their citizenship in certain ways, or?
So there have been cases where citizenship is gained by naturalization. You can lose, like in the case of Nazis who come over, they were given citizenship as naturalized citizens. And then it turns out that they were, in fact, concentration camp guards or something like that. They can be stripped of their citizenship on the legal theory that they never should have gotten it, that it's in effect annulled. It was granted to them under false pretenses, hence it can be taken away. But the criminal law, I mean, it's interesting because it raises a broader question, which is even the 14th Amendment, having spent some time on citizenship, then moves on to due process and equal protection of the law, which it defines in terms of persons, which has nothing to do with citizenship as a much broader category. It was always less inclusive than it might have been, but it's not a citizenship question. And so in a way, again,
A lot of court cases
a lot
have come from those.
But I guess
If I can jump in, I think part of also, to Scott's point, is this question of what protections does citizenship provide? And I don't think that all citizens don't have equal protection under the law, and generally have not had equal protection under the law. And so I think that, in cases, whether, kind of new, like the recent, the 14-year-old kid in Texas, Ahmed Muhammad, or others who, no, he's not a case of his citizenship being taken away, but there's certainly issues of national origin, race, and religion that are affecting his experience of justice and the criminal justice. And so citizenship is not protecting him against various types of discriminatory involvement. And so that happens too with questions of espionage or terrorism or who's likely to be suspected of things. I mean, the FBI has just dropped charges against a professor who's a US citizen of Chinese origin who was allegedly selling secrets to China. And it turned out that the FBI who was charging him with this didn't actually understand the science involved, that whatever plans they thought he'd sold to China were not of the particular device involved in some type of supercomputing, that it actually, I think it's superconductors, that they didn't understand, but it was basically a suspicion on the fact that he had family in China and that he had what we're seeing as sort of dangerous ties potentially to China, even though he's a US citizen, even though he didn't break the law. So does every citizen have equal protection under the law? Not generally in practice. Certain people for various reasons would have less protection.
And we can go back to your point too, even earlier, I think, which is relevant. What is citizenship? Women under coverage could not vote. Felon disfranchisement, or we consider these people still citizens, but in many states, they do not have the right to vote, which you defined it. I mean, that's the point I made about Emancipation Proclamation. Without a vote in a democracy, are you really a citizen? Are you, to go back to your point, I thought it was so good, at what point are you participating, or are you just in the sense of this monarchy, or the medieval sort of concept, or as a participatory, whatever nationalism thing. I think it's also interesting, certainly in the 19th century at least, and somewhat later, people conflated the idea of nation, nationalism, and race. People would speak of race, including, a race of South Carolinians, talking about what, not at all along the other. So all these things sort of get worked out, and that's why the 14th Amendment, I think, is so important. It's going to be interesting if we start tampering with it. And it is subject to interpretation. When I talked about it, it was because of this Supreme Court ruling. You don't really have to change the Constitution. The Supreme Court can rule on this issue of birthright citizenship, as it did, in the 1898 case. For a lot of people say, well, they said they're going to change the Constitution. They don't really have to. They can elect the right president that they want, to appoint the Supreme Court justice they want, and you can follow all these cases and see those 5-4 decisions. I think it's a very interesting time as a historian.
It's interesting that after the 14th Amendment, it's very hard to make the case in America. I mean, there's lots of discrimination based on race and gender and other things, national origin, but it's very hard to define America as a race, the way sort of German citizenship was thought. That option almost gets taken away. Because perhaps because it's all sort of surreptitious how they're getting around. They're getting around very effectively, but never directly, because the law is so.
Isn't it the Constitution that makes us a nation, as opposed to, that's one argument. Why it's so important, which why it frustrates me so much if we don't study it more and do understand how air conditioning works better than the Constitution says it should.
I did used to tell my con law students, you can borrow this if you want, but on the very first day of the class, I would quote Thomas Reed Powell, who was the dean of the Harvard Law School in the 20s, who told his constitutional law students, you can read anything you want in this course, except the Constitution of the United States. It will only confuse you.
It's a confusing topic.
I have a question, and I think perhaps I'm picking up on your interest in being able to label someone a terrorist. As you were speaking, I was thinking of the Korematsu case, the internment of Japanese Americans. They were American citizens, from my perspective, undeniably persons, and nevertheless, they were taken to internment camps, concentration camps, you might call them, and their property was taken. And I wonder if you might speak to the conditions under which, in the past at least, our government has seen its way clear to deny certain things that seem to come with one's being a citizen or a person, because both terms are in the 14th Amendment.
Well, you can certainly take it back to the Civil War and Lincoln's habeas corpus decisions and things. And I think in all these cases, as we look back on in particular, it's a pretty horrific thing that the United States did in terms of the Japanese, but they would have justified it in terms of threats
Okay, and now that picks up, I think, on his concern about terrorism,
Mhm.
because the evidence available of the real threat that Japanese Americans pose was very.
How many people go through a airport screening with a, say, a turban on and aren't going to probably be pulled out and searched?
I suppose the little white boy had brought his clock that he made at home to school. I don't suspect that the police would have been involved at all.
No, and I think that's where we get these questions also of sense of both of wartime exigencies, whatever's going on with the government feels like it can encroach, and if there's a war on terror, and how does that sort of also justify broader encroachments on citizens' rights? But also these ideas of trying to identify the threat. That there's something that there's almost like a visible marker. It's interesting if you looked in a class before that I taught that if you look at the Time magazine cover story after Pearl Harbor, there's this American flag on the cover, and then this one major article in that Time magazine was how to identify the difference between a good Chinese American and a dangerous Japanese American. And they had these sort of phenotypical demonstrations of character, was sort of how it's being pointed out. Like, look at the shape of someone's eyes. First of all, you'll be able to identify the difference between people's nationality based on these phenotypical markers. But secondly, you can see what's sinister, what's friendly, where is good character represented in someone's body and their appearance. Where should you be concerned about warlike, menacing appearances? And the idea was that you could identify the difference between a threatening figure and a non-threatening figure based on their appearance. And you saw it again after 9/11. The comment about turbans made me think of it, of showing there were, again, I don't know if it was Time or it was another major periodical, published different types of headgear worn by different religious minorities in the Middle East or Southeast Asia. And you saw that the Sikh turban, that's a good turban, that's a safe person. The Taliban turban, that's a different type of turban, and that's a dangerous one. And so basically showing different people with different types of illustrated headgear is showing what's a good person, what's a good citizen, what's a peace-loving person, a democracy-loving person, and what is a sign of a religious totalitarian regime. And so the idea again was that you could look at someone's appearance, their headgear, and identify that. I think that also comes in this idea that we want to be able to see a threat.
So we need better social science education to do better. But you know, you have Israel as a good example, I think, of a society, as a nation, as a country that sees itself in a very precarious situation. And where are we in the United States with our laws and our tradition and things? We draw lines at what is acceptable and what Israel would draw lines at what is. And it's too easy to make, I think, judgments without putting things into a historical context, which we often get wrong.
I think the theme here is that citizenship, the mere fact of citizenship doesn't protect you from a government that is trying to limit your